Good morning, everyone. It is 10 a.m., but we still have people coming in. We're going to get started in just a few moments. So I do have 10 a.m. We have quite a few people in and we are recording this session. So I think we can go ahead and get started. And those folks that come in late will be able to go back and hear our introductory comments. My name is Lori Levy. I'm General Counsel and Vice President of Legal Affairs here at Texas Realtors. And today we are bringing you legislative changes that occurred in the last session and what those mean for your real estate business. We have all of the in-house attorneys here today presenting to you. We have David Jones, Iman Ali, Robin Harris, Denise Carr, Mandy Balch, and we have our legal administrative assistant, Chelsea Nobert, at the helm, helping with the webinar. These are the folks that read the bills that were filed during the session. We work closely with the government affairs team. They had bill readers on that team as well. And we did review over 2,000 bills. We read all of the bill captions to see what we needed to follow, but we did track over 2,000 bills. In the July Texas Realtors magazine, you can see the wins that we had at the legislative session. And then the August magazine will include information from this webinar highlighting the bills that you need to know as they affect your real estate business. For the bills that we're going to review today, most all of them have a September 1st start date or effective date. Some of them do have a different date. Those will be noted. But if you don't hear that noted or don't see that on the screen, it is a September 1st start date. If you have additional questions on any of these bills that we cover today, you can find out more information online. You can go to capital, capital.texas.gov. Capital.texas.gov. You can look up any bill there. So if nothing else today, make sure you write down those bill numbers and whether it's a House bill or Senate bill, and you can go find out more information. In addition to that, the slides from today that do have the bill numbers on there will be posted on texasrealestate.com under webinars, and the recording of this webinar will be at our YouTube channel, youtube.com/Texas Realtors. We will be taking questions at the end if there is time. If I see any questions come in that are pertinent on a bill that's being discussed, I will ask the presenter to go ahead and address that question if they are not already planning to provide that information. With that, we are going to go ahead and get started. Our first presenter today is Robin Harris.
Thanks, Lori. Good morning, everyone. This first bill that we're going to be talking about relates to appraisers specifically. I think that we've all noticed some shortages in the numbers of appraisers, some issues with timing of appraisals within the transactions. We're hoping that this bill will address some of that. So currently there are about 6,400 appraisers. That's as of March 2021, about 6,400 licensed appraisers in the state, and that's all levels. And so when a lender is looking at a property, there are different types of appraisals that they can use, and one of those is called an evaluation. That's an appraisal light, I guess you could call it. They don't have to do an in-person inspection. They are able to use different sorts of criteria and look at different items to get the valuation. In December of 2020, the Attorney General's office issued an opinion letter stating that licensed appraisers in Texas were still required to comply with all of their licensing requirements. They have to follow what's called USPAP, which governs what appraisers are required to do when generating an appraisal. They were required to comply with USPAP even for evaluations. Evaluations don't even have to be done by a licensed appraiser, according to federal guidelines, or for the lender's requirements. But in our state, the Attorney General decided that they did. So what this bill does is specifically exempts those evaluations from having to comply with USPAP when they're done. The hope is that moving forward, that it will be something that attracts, keeps appraisers in the industry. It's an additional income stream because they're able to do these quicker evaluations, make a little bit more money doing those in addition to the normal appraisers, and not be shut out from those. So after appraisers, we're going to go on to fair housing. I'll pass it off to Iman.
Thank you, Robin. Good morning, everybody. So I'm going to be discussing a couple fair housing bills that are probably not going to affect your day-to-day adherence to fair housing rules. However, this information may be helpful for those working with their own properties or for those keeping up to date with Texas fair housing changes. So the first bill we're going to talk about is HB 1153, and the changes introduced by this bill bring the Texas Fair Housing Act in line with the relevant sections of the Federal Fair Housing Act. And so what does that mean? HB 115 clarifies that the Texas Fair Housing Act, or several provisions from that, do not apply to the sale or rental of a single family house sold or rented by the owner under certain circumstances, including if the house is sold or rented without services of any person in the business of selling or renting a dwelling. Those provisions also do not apply to the sale or rental of rooms/units in a dwelling containing living quarters that are occupied or intended to be occupied by not more than 4 families living independently, if the owner is also going to be maintaining and occupying one of those living quarters as their residence. The bill also gives a definition for who is considered a person in the business of selling or renting a dwelling, makes that crystal clear. And it adds a prohibition against, that the prohibition against using a person in the business of selling or renting does not apply to using attorneys, escrow agents, title companies, etc., persons that would be necessary to transfer title. Okay, and the next bill is SB 30, and this bill creates a new process for removing discriminatory covenants from deed records. And the bill defines a discriminatory provision as a restriction or provision that is void because it prohibits the use or sale, lease, transfer to a person because of their race, color, religion, or national origin. The bill allows a property owner to request the removal of such a discriminatory provision from the deed records by filing a motion that they verify with an affidavit, and they file the motion with the district court in the county in which the deed is recorded, or with any other court having jurisdiction over property matters in that county. If the court does not rule on the motion on or before the 15th day, that motion is considered granted. And so it kind of makes this process pretty easy and allows a judge to kind of look at that affidavit and the deed record in question and make that decision even without speaking to the parties.
Aman, on this bill, I just want to point out that this is a new mechanism to remove certain deed restrictions from the deed records, but these provisions are unenforceable, even if they remain in. So it doesn't mean that all property owners necessarily have to take this action, but there has been a push, not only in Texas, but nationwide, to try to remove these provisions from the deed records. Different states are handling this in different ways. The Texas legislature chose this way, that the property owner can go to the court and ask for that. So we will be watching that closely to see, once this takes effect, how many property owners are taking advantage of that and what that result is. But I just wanted to make sure we are clear that these provisions are unenforceable, even if they remain in the deed records.
That's absolutely correct. Thank you for that clarification, Lori. And next, I'm going to hand off the presentation to Mandy talking about HOAs.
Thank you, Iman. The HOA bill is Senate Bill 1588. This bill is intended to bring more balance between the rights of property owners and homeowners associations. We at Texas Realtors are very proud of this bill. Our Realtors team did an outstanding job of negotiating, advocating, and building support for SB 1588, both in and around the Capitol and with the general public. It actually became one of the biggest successes around the Capitol this session. This is a big bill that covers many facets of the management of an HOA. And today we are only going to talk about a few of those areas that specifically relate to real estate sales and leasing. First, there is a provision in SB 1588 that caps the amount of fees that an HOA can charge for the production of subdivision information, resale certificates, and updated resale certificates. For subdivision information, that will be capped at $375. And for resale certificates or updated resale certificates, the amount would be $75. The next area that we want to talk about is our provisions that add availability of information, making it more easily accessible. The bill calls for the Texas Real Estate Commission to create a publicly accessible database of HOAs. And that has to be done by December 1st of this year, 2021. If any HOAs have already filed that particular information with the counties, they will have until June 1st of 2022 to file with the state database. But this is the first database of this kind that will be available to everybody. The next provision is a requirement that HOAs with 60 lots or more will be required to maintain websites where management certificates and dedicatory documents are all going to be made available. Also, it will have to provide notification of any meetings or issues regarding that particular HOA. SB 1588 also protects owners and tenants' private information by prohibiting HOAs from requiring access to lease agreements. The only information that will be required will be basic contact information and the beginning and end dates of the lease. The new law also provides many other protections for homeowners, including barring HOAs from prohibiting certain pool enclosures, security measures, and religious displays on the homeowner's property. There are some exceptions to that, but this is going to be a huge change in what the homeowners association can prohibit. The bill also is going to be a big improvement over current law because it provides much needed due process in the resolution of disputes between homeowners and their HOAs. It also will put some limitations on the HOAs, preventing them from taking certain actions like reporting to credit services, anything as long as they have not complied with the regulations that this law puts on the HOAs. This has been a long process. There are an awful lot of provisions that we don't have time to tell you about today, but we will be providing more information in the future. And I think now I'm going to turn it back over to Robin. And he's going to be talking about business regulation and employment practices.
Yeah, thanks, Mandy. So it's important, we recognize that while y'all are out there selling and buying and representing clients, running a business is the other part of things that you do. So there are some important items to be aware of that came out of this last legislation that will kind of help you and moving forward on that business side of things. The first thing, SB 6, that's the big Pandemic Liability Protection Act. So if you remember, we get in our time machines and go back to March 2020. Nobody knew what was going on or what was happening and what we were at risk for, showing a client a home, or even if we could show homes. So this is something that, the governor particularly and the legislature wanted to get in to protect business owners, including realtors, from civil liability for pandemic related lawsuits. So infecting someone or causing damage to property because somebody who was infected with COVID at the time that they came in, may have spread the disease, something like that. This will offer protections. Here's the thing though, is that as a business owner, you must act prudently. You can't just ignore what the guidance is from the local, state, and national health authorities. So you have to have some protections in place for clients and customers and just the general public as you're moving forward. I think that we did a pretty good job of that, or not we, I think that you, the members, did a pretty good job of that moving forward, working through the past 18 months. And so that will just provide that an extra layer of protection. Next bill is SB 45. This is something that makes employers responsible for a sexual harassment claim. This isn't something that's new, and I recognize that a lot of Realtor members don't necessarily have employers. They have independent contractors, or they are independent contractors, but there are some folks who run a brokerage who have assistants, have employees of some sort. It's important because while it's not completely new, it does reduce the employee level from 15 to 1. So if you have even one employee, and it doesn't that I saw differentiate between part-time and full-time, just one or more employee. So it's important to consider that, think about that, look at employee handbooks if you have those, or office manuals, and maybe consider updating that, speak with an attorney about updating that. Last business related bill is SB 968. So this is one of those, there was a lot of talk about what the governor is and is not allowed to do with emergency powers. And so this is a pretty big bill that covers a lot of things. But what it does, and again, if we go back to March 2020, wondering who or what kind of business could be done at that time. And in one of the governor's emergency orders included the federal designation for emergency essential services. And so realtors, real estate services was included in that. So what this does is takes the federal part out of it, and it's a state designated essential service at this time. So buying and selling real estate and all the peripheral real estate related services, title, appraisal, inspections, all of those types of services and construction are deemed emergency services. And they cannot be limited in a time of emergency and in a time of a pandemic. So that's one part, and that's a good thing. What the bill also does is prohibits government entities, so state or local government offices, from issuing vaccine passports. So they can't require a member of the public to be vaccinated before coming in, basically is what it means. They can't require vaccination to serve on a board or to be a member of a governing body. It also prohibits businesses from requiring customers to provide proof of vaccination if the business receives government contracts. So if you're a service that contracts with the government to, and I believe that this is state contracts, if you're an entity that buys or sells for the state or helps with that, I don't know if you can do that, but if you do, and you want to continue contracting with the state to provide those services, this is something that you need to be aware of, that the business cannot require proof of vaccination if you want to receive those contracts. So a little bit of a different twist. Like I said, this is a really long bill. It includes a lot of information, but these are the pieces that apply to y'all's businesses and just to be aware of. So after business issues, we've got some special purpose district updates, and I'll pass it to David.
Thank you, Robin. Before I begin, we did have a question come in regarding the previous fair housing bill. So before we get too far away from that, I will turn it over to Lori.
So our participants are a quiet group today, but we did have a question come in related to fair housing, and it is, can deed restrictions still include language discriminatory against the LGBTQ community? The technical answer to this question is yes, because the bill was limited in what it did address, and it addressed race, color, religion, and national origin. It did not include LGBTQ, but as I said earlier, there are restrictions that are unenforceable, and under fair housing laws, state and federal, that those communities would still be protected. Fair housing protects sexual orientation and identification. So the answer is no, they cannot be discriminated against, but under this bill, there's not a removal process for those provisions from the deed restrictions. Thank you, David.
Okay, so my first bill is HB 1154, and this is basically a transparency bill for special purpose districts. And so we're talking municipal utility districts, freshwater supply districts, water improvement districts, all those sorts of districts. In the previous legislative session, 2019, a new law was passed that required such districts to maintain an internet website and to keep certain information on that website for transparency, so the public knows what's going on with these districts. So this bill just adds on to that, and it has an additional 15 required pieces of information that these districts have to keep on their website. I won't read all of them, but some of them are the name of the special purpose district, the name and term of office of each member of the governing body of the district, the rate of any ad valorem taxes, rate of any sales or use taxes, and information about the meetings, the time and place of the meetings, the minutes of the meetings, and the most recent financial audit. Okay, next bill is 1543. This is a big change, folks, so I'm going to need you to stop all the multitasking. The emails and the text messages can wait. Get off your Candy Crush and your solitaire. You got to pay attention to this one. This one is basically adding another seller's disclosure. So we are all familiar with the normal seller's disclosure notice that is required for sellers of one dwelling unit to give to the buyer. This is going to be another one. This one deals with properties in a public improvement district. Now, what's interesting is there's already a requirement for sellers, if their property is in a public improvement district, that they have to notify the buyer. The current one is kind of watered down compared to what they just changed it to. You can satisfy the current requirement with just a generic notice. It's actually already in the contracts, the 1 to 4 family contracts. It's already in there. It's paragraph 6E as an elephant, 6E subparagraph number 7. It's in one of those, I call them flyover paragraphs. Those are the paragraphs where there's no blank line for anybody to fill in, so nobody really kind of pays attention to it, but it's already in there. And it basically just says that as a purchaser of this real property, you are obligated to pay an assessment to a municipality or a county for an improvement project. More information concerning the amount of the assessment and the due dates of that assessment may be obtained from the municipality or county levying the assessment. So that's what's already in there. It's very generic. The generic notice won't work anymore after these changes. Some of the highlights of the new changes are, it now applies to all property types, all, including condos and commercials. The current language only applies to not more than 1 dwelling unit, and condos were specifically excluded. So now all property types, the seller is going to have to provide this notice to a buyer if the property is within a public improvement district. It requires, the new notice requires specific information about the improvement district where the property is located. So that's why the generic notice doesn't work anymore, because you have to identify what improvement district the property is in and what municipality or county is levying the assessment. The buyer is required to sign the notice as evidence of receipt. And a separate copy of the notice will also be executed by both buyer and seller at the closing. That will become important later on. So now what happens if seller does not provide the notice? So here are the penalties. If seller does not provide the notice prior to or during the contract execution, the buyer may terminate the contract. It's similar to what happens with the seller's disclosure notice, but with the seller's disclosure notice, there's a 7-day cutoff. So if the seller does not give the seller's disclosure notice prior to the contract being executed, the buyer can terminate. But once the seller does give the buyer the notice, there's a 7-day period where the buyer can terminate. This bill does not have the 7-day cutoff, which means that the buyer presumably can terminate all the way up to closing if the seller does not provide the notice at or before the contract is executed. If the seller does provide the notice after the contract is executed and the buyer elects to close, then the buyer waives all their rights they waive their right to terminate, obviously, and they also waive their right to recover damages. So yes, there are damages associated with this. If the seller completely fails to provide the notice at any point, not before, not after the contract is executed, buyer has a right to file a lawsuit for damages. There are 2 types of damages, and the buyer has to pick one or the other. One of the types of damages the buyer can sue for is a suit for damages for all costs relative to the purchase of the property, plus interest, plus attorney's fees. With that one, the buyer, though, does have to basically give the property back to the seller. It's basically a do-over. You didn't give me the notice, here's your property back. The second type of damages is very generic, a suit for damages not to exceed $5,000 plus attorney's fees. So it's basically a free shot for a buyer to sue the seller for $5,000. Now, there is a statute of limitations for this suit for damages. It is 90 days after the buyer receives the first assessment from the improvement district. or 4 years after the property closes, whichever one comes first. Now, here's where the closing, the additional notice must be signed at closing. If that notice is given at closing, then the buyer may not sue for damages. So that notice being signed at closing becomes extremely important because now you're cutting off the buyer's right to sue for damages. Now, the buyer would still keep the right to terminate the contract, but if the buyer does elect to close, as long as that notice is given at closing, then the buyer can no longer come back and sue for damages. There are a few exemptions from the notice requirement, and they are very similar to the same notices regarding the seller's disclosure notice. So it does not apply to transfers under court order or foreclosures, bankruptcies, by a fiduciary in the course of an administration of the decedent's estate. So when the executor is selling the property from one co-owner to another. So the same, there's about 10 of them. The same that apply for seller's disclosure, same exemptions apply for this notice. Okay, so here's what's going to happen next. The forms, both the contract need to be updated, and TREC is currently working on those. The 1 to 4 family, the new home contracts, both complete and incomplete construction, the residential condominium contract, and they're going to have to add something to the unimproved property contract because currently it's not required. Texas Realtors will also do the same with our forms. So our forms that have similar provisions are the new residential condominium contracts, completed and incomplete construction, and our commercial contracts, improved and unimproved. We're going to have to add all these because this disclosure requirement now applies to all transactions. So that's why everything's now going to have to get updated. TREC is also promulgating a new notice form that will meet this new disclosure requirement. And I believe we have a copy of it on the next slide, their draft. So this is what the draft looks like. Don't everybody try and copy this. It's just a draft. TREC will put out the final version before the deadline. This bill and this requirements are effective September 1 of this year. So all transactions, all contracts that are entered into on or after September 1, this public improvement district notice is going to be required with sellers. TREC next meets on August 9th, and that's when they will adopt for emergency purposes this version of the notice. But as we understand, they are currently concurrently going to go through the normal process, and they will take comments and all of that. But for now, just to meet this September 1 deadline, they're going to put up a notice. Question.
So we did get a question, but before I ask that, just to clarify, TREC, they will adopt the changes to the forms and a new notice at the August meeting on an emergency basis. That will make those updated forms available for use for September 1. In addition to that, they are posting at the same time through their regular process. So there will still be an opportunity to provide comment on these changes, and TREC will then consider those at the next meeting. But because of the timing issue, all of our members, all license holders in Texas will have access to updated forms in time for that September 1 start date. We did get a question in, David, that is, where do we get this notice? We are currently working with TREC, but also with our forms vendors, and then we are working on a communication plan so that we can get the word out to our members about this change. And that new notice and the updated forms will be available everywhere forms are available now. So on the TREC website for TREC forms, on our website for all of our Texas Realtors forms, including the TREC forms, and then with all of our licensed forms vendors, ZIP forms, which is a member benefit for you all, and then the other forms vendors as well. We are working closely with them to get the updated forms out as quickly as possible prior to that September 1st start date, but also to make sure that they help us get the word out to their customers that are you all, to make sure everybody is aware of this new requirement timely.
Thank you, Lori. Okay, just a couple more points with this bill. Each public improvement district is required to maintain what's called a service plan, and that plan gets filed with the county clerk. It includes, the amount of annual indebtedness, projected costs. This bill now is going to require that service plan to include a copy of this required notice, and that's going to be filed with the county. So all of these notices for each of the public improvement districts, they will be public, and you and your clients will be able to receive a copy of these notices from these public websites. Last point, there is some limited liability worked in. So title companies, real estate brokers will not be liable for the damages portion for failing to provide the notice if the improvement district has not filed the service plan with the county clerk as they are required to, or even if you unintentionally provide the incorrect notice. And now that's just the limit of liability for the damages portion. If the notice isn't given, the buyer would still have a right to terminate. So that part, there's no limit to that part. And with that, I think I'm over my time. We do have
One more question,
Another
but on 1154, the other bill, not this disclosure one, there's a question. Does that include water districts and groundwater conservation districts? I don't know if we have that information in front of us.
let's see, it specifically does not include municipalities, counties, junior college districts, river authorities, or any statewide political subdivision. I believe it does include groundwater conservation districts.
And if that is not correct, we will correct that later, but it does include groundwater conservation districts. Thank you.
Okay, and finally, keep an eye out for any communication from Texas Realtors. We will be pumping out a lot of information regarding this. So if you haven't already, sign up for emails and our newsletters, because we're going to be pushing out a lot of education for this one. And with that, I will turn it over to Iman, who will discuss some eminent domain bills.
Thank you, David. So the following bills may be helpful if you or your client is faced with condemnation by an entity exercising eminent domain powers. All three bills in this section are intended to provide property owners with more information about the eminent domain process, as well as to provide avenues to report misconduct. So the first bill we're going to talk about is House Bill 2730. And that bill requires that property owners be made more aware of their rights when an entity seeks to acquire their property through eminent domain. And so the eminent domain entity is required to provide information through a landowner's bill of rights. And if that bill of rights is not given to the property owner, or other misconduct occurs, then the bill allows property owners to file complaints with TREC. The bill also lists there's a long list of what must be included in what would be considered an initial offer that is a bona fide offer, meaning a good offer, a proper offer. This is one of the bills that has a different effective date, and this bill is effective January 1st, 2022. The next bill, House Bill 4107, requires that common carrier pipelines exercising the power of eminent domain provide notice to property owners, as well as indemnification, which means redress, for damages caused when accessing the property for a preliminary survey. And this notice must be given not later than the second day before the entry to the property. The bill also limits entry only to the portion of the property that would be anticipated to be affected by a route of the proposed pipeline, and also limits entry only for the purpose of conducting surveys. And lastly, Senate Bill 721 requires that an entity exercising eminent domain power provide disclosure of all appraisal reports used in connection with determining the entity's opinion of value of that given property. And that must be given not later than the 3rd business day before the date of the special commissioner's hearing. If any appraisal report is to be used at that hearing, they all must be given to that property owner. And as is with all these bills, I'm sure you're aware, but the changes made by these bills apply only to proceedings, condemnation proceedings that would occur after the effective date of the bill. And that's it for me on eminent domain. Next up, we have Mandy with home and other warranties.
Thanks, Iman. We just have a couple of bills from this session that deal with home warranties or other related warranties. The first is House Bill 2110. This is really a very good common sense bill. It's the kind that we all love to see. And it's very simple. It just simply provides for the automatic transfer of a manufacturer's warranty on air conditioning systems or components of AC systems to be conveyed with the residential real property as if the new owner of the air conditioning system is the original purchaser. No forms will need to be filled out and no fees are allowed. So if the warranty on the AC system still has some time left on it, a new buyer will really appreciate this extra benefit. And I call this good government. The other bill is House Bill 1560. This is actually the sunset bill for the Texas Department of Licensing and Regulation. But we are interested in one little portion of the bill that transfers the regulation of residential service contracts from TREC to TDLR. This is actually a very sensible decision. TDLR has lots of experience. They handle a lot of warranty regulation, so it's a perfect fit for them. And just remember that all pertinent Texas Realtors forms will be updated to reflect this particular change. And now I'm going to turn it back over to Robin for windstorm insurance.
Thanks, Mandy. Y'all thought you were done with me for the morning, but not even close. Okay, so windstorm insurance. So these will apply to coastal counties, specifically counties that are covered by the Texas Windstorm Insurance Association. If you're covered by TWIA, you know it because you're on the coast. There's a sliver of Harris County that TWIA covers also. They provide that level of insurance that a lot of insurance providers don't provide. So these couple of bills, what they do is HB 2920, that gives policyholders an extra 10 days after their policy has expired to renew the policy. So if you get the notice, your customer gets notice, they're able to have that extra 10-day extension for whatever reason to get that renewed. And we all know how important, if you live on the coast, to have that, especially this time of year. So something to pay attention to. HB 3564, it's just a small change, but it relates to what the Texas Department of Insurance can do for TWIA covered properties. Previously, TDI could reject or rescind a permit that was issued for repairs done to a TWIA covered property if they felt that the construction was not done up to certain standards. So what this does is takes that away from TDI, takes that rescission power and just gives it back to TWIA. As long as the property is done pursuant to TWIA standards, then that certificate of compliance, that property can't be rescinded and the repairs can continue. So that's our brief windstorm insurance update. And now we have Denise with a property tax and appraisal update.
Thank you, Robin. So there were a number of bills that were passed during the regular session that impact aspects of property tax and appraisals in the state. These bills are not as exciting as some of the other bills that you've heard about this morning, but they are important all the same. So during my time, I'm going to hit some of the highlights of 8 of these bills that were passed. So first we have Senate Bill 63. This was passed to allow the comptroller's office and the taxpayer to give and receive electronic communications. This legislation also establishes certain deadlines for the appraisal review board process. And seemingly unrelated, Senate Bill 63 also establishes an exemption from property taxes imposed on solar or wind powered energy devices installed or constructed on real property that is primarily for the production and distribution of energy for on-site use. And so the device owner is entitled to this exemption even if they do not own the real property to which the device is attached. We then have Senate Bill 742, which amends current law relating to installment payments of property taxes on properties owned by businesses that have been damaged by a disaster in a disaster area. What this does is it adds that installment payments are also available if the business-owned property has been damaged by a proclaimed emergency in a designated emergency area. This legislation also clarifies that at the discretion of the taxing unit, installment plans are available for businesses in disaster or emergency areas, even if the business has not been damaged as a direct result of the disaster or emergency. Senate Bill 1427 was passed with the intent of clarifying and confirming that the existing temporary property tax exemption available for qualifying property damage during a declared disaster applies only to physical damage to property and does not include economic damage. Then we have House Bill 2723 that was passed with the help of Texas Realtors. This legislation improves the accessibility and awareness of truth in taxation websites maintained by appraisal districts by creating a statewide website that provides a separate link to the internet location of all property tax websites. So that's a centralized website that will link you to all the individual sites. This bill, unlike some of the others we've discussed today, this takes effect immediately. So Chelsea, I think we can move to the next slide. Thank you. House Bill 988 was passed to give taxpayers more teeth to enforce certain procedural requirements pertaining to a taxpayer's protest of their property taxes. One example, the legislation establishes a taxpayer's right to bring suit to compel an appraisal district or appraisal review board to comply with procedural requirements. Senate Bill 1088 was passed to exclude lessors of personal property from the obligation to provide notices of appraised value of personal property to their individual lessees. So now this obligation to provide this notice applies only to lessors of real property. Then we move to Senate Bill 1854. This legislation establishes that certain qualifying elderly, disabled, or disabled veteran homeowners will not be required to pay taxes on a homestead property that is subject to an appeal through binding arbitration of an appraisal review board order during the pendency of that appeal. The legislation also provides that taxes are not considered delinquent on the property of the qualifying elderly, disabled, or disabled veteran, which will allow such individuals to file for an appeal through binding arbitration. And finally, we have Senate Bill 1919. This legislation allows a property owner to participate in tax protest by video conference in addition to phone in most circumstances. So with that, we go back to Iman.
Thank you, Denise. So the following bills will have an impact on day-to-day leasing and property management transactions, so please do listen up. And let's start with HB 531. So House Bill 531 requires landlords to give notice to prospective tenants, residential tenants, at or before the execution of the lease, of whether they are aware that a rental dwelling is located in a 100-year floodplain, or whether the rental dwelling has flooded at least once within the previous 5 years. The notice must be in a separate written document given to the tenant, again, at or before the execution of the lease. If a landlord fails to provide the notice and the tenant suffers substantial damage to their personal property as a result of flooding, then the tenant may terminate the lease with written notice no later than 30 days after the date of that damage. However, the tenant may only do so, again, if they suffered substantial loss or damage of their personal property. And substantial loss is at least 50% of fair market value.
On that one, Iman, will we be providing?
Yes, so this is one of the bills that has a later effective date. It is going to be effective January 1st, 2022. And Texas Realtors will absolutely be updating our forms to add this new required disclosure. So like David mentioned, go ahead and subscribe to our newsletters and keep checking the website so that you are well aware of when this form comes out and how to advise your clients on using that. I should also mention that landlord is described in this bill as the owner or the lessor or subleaser of the dwelling. It does not include a manager agent of the landlord unless that manager or agent purports to be the owner, lessor, or sublessor in an oral or written lease. Okay, next up, we have HB 900. And HB 900 adds to the writ of possession section of the property code that a landlord is not liable to a tenant for any damage resulting from an officer executing a writ of possession in an eviction suit. This section of the property code already allows the officer executing the writ to physically remove uncooperative tenants and their personal property, and already stipulates that the officer is not liable for damages as a result of that if that officer acts in good faith and with reasonable diligence. So this bill is now extending that protection to the landlord as well. And lastly, we have Senate Bill 1783. And this bill allows a landlord to choose to offer a tenant an option to pay a fee in lieu of a security deposit. The agreement to collect such a fee must be in writing and signed by both the landlord and the tenant, and that fee must be a non-refundable recurring fee in equivalent amounts, meaning it cannot change from month to month. However, the landlord may not use a prospective tenant's choice to either pay the fee or security deposit as a criterion in determining whether to approve an application for occupancy. And the landlord must also inform the tenant when presenting that choice that they also have the option to terminate the agreement to pay the fee in lieu of a security deposit at any time, and instead pay a security deposit in an amount that is offered to new tenants for substantially similar dwellings. The bill allows that fee to be used to purchase insurance coverage for damage and unpaid rent for which the tenant is liable under the lease. However, this does not excuse the tenant's requirements to maintain those fees and keep paying according to their lease. It's just insurance for the landlord. However, a landlord may not charge the tenant a fee that is more than the reasonable cost of obtaining and administering such insurance. A landlord is also prohibited from submitting a claim to the insurer unless the landlord notifies the tenant of those damages, including written descriptions and an itemized list of damages. no later than the 30th day after the tenant surrendered possession of the dwelling. Such a claim cannot include normal wear and tear. If the tenant successfully challenges the claim for damages or unpaid rent, then the landlord may not file an insurance claim for insurance purchased with a fee. If the landlord has already submitted a claim to the insurer, then that claim must be withdrawn. If the insurance company has already paid the landlord for an invalidated claim, then the landlord must return the payment. However, if the insurer has paid a landlord for a valid claim, then the insurer may be able to seek reimbursement directly from the tenant for the amount paid, if done so before the first anniversary of the termination of that tenant's occupancy. And that's it for me. Next up, we have Robin with protection of elderly.
Thanks, Yvonne, and don't worry, y'all, this is the last time that I'm up, and I'm actually the last bill, so we'll have some time for questions. So just this one issue on protection of the elderly. What it does is target specific predatory practices by family members, property owners, caregivers, and it includes people with a fiduciary duty. It is now a crime to exploit or financially abuse an elderly person. So previously, there may have been an issue with these types of practices, selling an older person's property, and they, a realtor may be liable for civil penalties, fraud, or deceptive trade practices. This actually carries criminal liability, and the category of crime goes up, whether it's misdemeanor or felony, depending on the value of the property. So most of these properties are going to raise it to felony level, but it's important to keep in mind what your relationship is with your client, who your client is, and what it is that you're doing, who you are looking out for, because including that person with a fiduciary duty, that's a pretty broad net right there. And so just something to keep in mind.
So Robin, on that bill, I wanted to point out that it was not drafted to specifically target realtors, but because of the language in there about people that have a fiduciary relationship, our members are absolutely included in that broad category, or potentially could be included in that category.
And this is something that we've an issue that we've been aware of in other states. We meet with E&O partners every year, and they've mentioned it a couple of times. This is not something that we were looking to include, but went ahead and passed in the legislature. So important to be aware of.
I was going to add that as well, Robin, that we have not seen these issues in Texas that we are aware of. We're not aware of any complaints, either with TREC or with E&O providers. We do have a relationship with 5 E&O providers that keep us updated on these things, but there have been such claims in California. And we always like to watch what's going on in California, because what starts there does tend to trickle over here to Texas. And so we watch that closely. We think that may be why this bill was filed, but it's just something to be aware of in your fiduciary relationships with your clients. And with that, we're at 10:58. There are currently no questions in the box. If I see any come in the next minute or so, we'll try to answer those. I want to remind you that additional information on these bills, some of the words that you heard that weren't on the slides, those will be in the August magazine of Texas Realtor that will come out in early August. So be on the lookout for that. We'll also push out some of the more specific information through our other communication channels, the leasing and property management, and so forth. This webinar will be published to our site later today. So just give us time. We've got to download it, and that always takes a little bit of time, but it will be posted later today. The slides will be there, and then the audio recording will be there as well. If you do find that you have a question that you think of later, please do call our hotline, 1-800-873-9155. We are always there to answer your questions and provide you with additional legal information. Thank you very much for your attendance. We look forward to seeing you hopefully at the Texas Realtors Conference in September in Houston. Thank you so much. That concludes our webinar.